It is my pleasure to welcome you to our Constitution Day celebration. A little background. The first written Constitution of the United States was the Articles of Confederation and Perpetual Union. Although written in 1777 primarily by John Dickinson of Pennsylvania, it was not ratified until March 1st, 1781 due to wartime delays. Significantly, under the Articles of Confederation, the states remained sovereign and independent stemming from colonial fear of a strong federal government. Congress was weak, with only the authority to make treaties and alliances, maintain armed forces, and coin money. The central government had no power to levy taxes or regulate commerce, two necessary powers for a successful government. So in 1787, the states called for a constitutional convention to amend the articles to fix those weaknesses. Between May 25th and September 17th, 16 weeks and 4 days, or 116 days, American state delegates gathered almost daily in Philadelphia to revise the Articles of Confederation. Early in this process, the delegates realized that amending the articles would be inadequate. Instead, they would need to create an entirely new document to establish a balance between state and federal power, a central government of limited and separate powers, reserving all other powers and rights to the states and to the people. The resulting document, our Constitution, had 7 articles. The first 3 articles define the limited powers of the federal government and its 3 branches. Article 4 defines the relationships among and between the states, the federal government, and the citizens. Article 5 tells us how to amend the Constitution. Article 6 gives us the Supremacy Clause, and Article 7 told us how to ratify the Constitution. On September 17th, 1787, exactly 237 years ago today, the Constitutional Convention delegates held their first meeting, at which they signed the United States Constitution. The states ratified it in 1788. The Constitution, which has been in operation since 1789, is the longest surviving written government charter. To encourage Americans to learn more about the Constitution, Congress established Constitution Week in 1956 to begin each year on September 17th. In 2004, Senator Robert C. Byrd of the great state of West Virginia sponsored legislation designating September 17th of each year as Constitution Day, requiring public schools such as West Virginia University to provide educational programs to promote a better understanding of the Constitution. Each year, the College of Law happily takes on that duty. The faculty selects a significant topic of constitutional law to discuss. Today's panel will speak about presidential immunity. As you probably know, Article 2 of the Constitution vests executive power in a president who can hold elected office for 4 years. That power is limited by the Constitution. Some of those constitutional powers are exclusive, such as the power to lead our military as commander-in-chief or to pardon those for federal crimes. Others are shared, such as the power to make treaties and to appoint ambassadors and federal judges with the advice and consent of the Senate. From the beginning, the United States Supreme Court has interpreted the Constitution to explain what those powers entail. Our panel is called Presidential Immunity. Today's guests will discuss the question posed in Trump versus United States, whether a sitting or former president can be criminally charged or convicted for acts done while in office, or is the president immune from such convictions? The answer to that question turns on whether those acts were official or unofficial acts, and whether official acts were conclusive and preclusive. I would now like to introduce our panel. Bob Bastress, the John Fisher II Professor of Law, will discuss the state of presidential immunity law up until Trump versus the United States. I will go next and discuss Trump versus the United States. John Taylor, the Jackson Kelly Professor of Law, will discuss the broader implications of the court's decision. Then Larry Rosenberg, a partner at Jones Day in Washington, D.C., and director of the College of Law's Supreme Court Clinic, will discuss whether the crimes charged in the January 6 cases, the Trump classified documents case, and the Trump hush money case, are official acts or the direct result of official acts, and whether and how the crimes charged in the January 6 cases pertain to the destruction or alteration of documents. And Professor Cody Corliss will discuss the decision's implication for the special counsel. Before turning the mic over to Professor Bastress, I want to thank our fantastic dean Amelia Reinhardt, and wonderful Associate Dean, Matt Titolo, for supporting the intellectual environment here at WVU College of Law. Let's also thank the ever-present and incomparable Ken Price for his technical expertise and the person who expertly runs this law school, Samantha Stefanoff. And last but never least, let's thank all the invisible workers who made today possible. Now let's give our panelists a warm West Virginia welcome and turn the stage over to Professor Bastress.
Well, I drew the easy assignment today because I'm talking about the background, our case law and other kinds of precedential background to presidential immunity from criminal prosecution. And it's easy because there's hardly any background. Trump versus the United States is the first case to present to the question to the Supreme Court about whether a former president can be criminally prosecuted for acts committed during his presidency and while acting as president. Gerald Ford, of course, spared the court the opportunity to have to decide that issue when he pardoned President Nixon. Otherwise, that might have produced such a case, but it's never reached the Supreme Court before. So I begin with the text, which is basically silent on the question of executive immunity from criminal prosecution. There are two clauses that might perhaps be relevant. One is the speech and debate clause, which of course creates a congressional immunity that senators and representatives, for any speech or debate they make, shall not be questioned in any other place. Obviously giving what has been construed to be an absolute immunity to congressmen for what they say in various kinds of official legislative acts. But there's no corollary to the speech and debate clause in Article 2, the executive branch article, which would provide any sort of immunity to the executive. The impeachment judgment clause is relevant. It says an officer impeached and convicted shall nevertheless be subject to criminal prosecution for the same conduct, which certainly implies that the framers envisioned the possibility for subsequent criminal prosecution for official acts. But that's not conclusive because the impeachment judgment clause applies not only to the president but also to judges and certain other executive officers. So it could certainly be the case that the president would still enjoy an executive immunity. The court has addressed presidential immunity and privileges in two contexts that establish some degree of relevant precedent. The first is with regards to presidential subjects being subject to criminal subpoenas issued by the courts. And the second is presidential immunity to civil liability. So I'll take up each of those. Presidential executive privilege from the subpoena process was first addressed by Chief Justice Marshall in United States versus Burr, which was the treason trial of Aaron Burr. But he decided the case sitting as a circuit judge. This was not a Supreme Court decision. It was an 1807 circuit court decision in which Chief Justice Marshall, who had been asked to issue a subpoena, asked by Aaron Burr, to issue a subpoena against President Jefferson for certain documents, decided to issue that subpoena and order the president to produce and comply with the subpoena duces tecum. The follow-up is that President Jefferson sort of complied, is the usual assumption, perhaps not fully. Nevertheless, it was essentially worked out, which has been the modus operandi, really, for these subpoena cases ever since. There was a subpoena as well of President Monroe in 1818, and he was advised by an opinion of his Attorney General to comply with the subpoena request. In 1866, the court decided Mississippi versus Johnson, in which Mississippi sued Andrew Johnson over the Reconstruction Act, but the court punted the question of whether it could assert its jurisdiction over the president. So that the issue of whether a president had to comply with judicial process remained essentially unresolved until the Nixon case in 1974. The Youngstown Sheet and Tube case, of course, was a challenge to presidential powers and their exercise. But as the name of the case shows, the steel companies sued the Secretary of Commerce and not the president himself. So the issue was not presented there. The Nixon tapes case, where a special prosecutor subpoenaed the Watergate tapes, the White House tapes that Nixon had recorded of his Oval Office conversations, was decided in 1974, and a unanimous court, Rehnquist not participating, decided that the president was subject to judicial power. So after 200 years, we finally got an answer to that question. And he does not have an absolute privilege from a subpoena. He has a certain limited qualified immunity to demand in-camera review to ensure the admissibility and relevance of the subpoena documents and to weed out any military and national security matters. But that's as far as that case went. The aftermath, of course, was that President Ford pardoned former President Nixon for his official acts. And that does reflect at least an assumption by Gerald Ford and by Richard Nixon, because he accepted the pardon, that Nixon could be subject to criminal prosecution. For better or worse, though, those two individuals have never really been considered giants of constitutional law. And then in 2020, the Supreme Court decided Trump versus Vance, which held that a sitting president was subject to criminal subpoenas issued by a state court in a state criminal prosecution. And of course, that was a prosecution of Trump himself, and he was required to produce the documents, subject again to certain kinds of judicial protections that the court outlined. The second context that was relevant was the civil action immunity, which in court addressed in Nixon versus Fitzgerald. Fitzgerald was a civilian employee of the Air Force Department and was essentially a whistleblower. And he was discharged from his job. The government claimed it was a reduction in force. He claimed it was retaliation for basically his exercise of First Amendment rights. And that court held the president was absolutely immune from civil liabilities, from civil actions for his official conduct. The emphasis there was on the fact that the president is a very visible target and that he could be seriously hampered in the exercise of his duties by a series of civil actions against him. And notice the diminished state interest with regards to civil litigation as opposed to criminal. And so the court concluded he was absolutely immune. And then, of course, Clinton versus Jones simply added that a civil action could be pursued against a sitting president for conduct committed prior to his taking office. The court concluded in that case that the civil action should not be a significant disruption to President Clinton's ability to conduct his duties. Unfortunately, Justice Stevens' opinion failed to point out to President Clinton that he needed to tell the truth in the civil case. Otherwise, it could be quite disruptive, and it in fact proved to be. But of course, criminal prosecutions are quite different from civil. There are all kinds of procedures which insulate individuals of any ilk from frivolous criminal prosecutions. There's exercise of prosecutorial discretion, there's the intervention of a grand jury, and various kinds of constitutional privileges and rights. So the specter that was emphasized in the Fitzgerald case of presidents getting sued right and left doesn't really apply to the criminal process. And of course, there are much weightier governmental interests in enforcing criminal laws as opposed to civil laws. And with that, I pass it on to Ann, I guess.
Thank you, Bob. So now that brings us to Trump versus the United States. Let me share the facts of that case with you. A federal grand jury indicted former President Trump for conduct that occurred during his presidency following the November 2020 election. That indictment alleged, among other things, that after losing the election, Trump conspired to overturn it by spreading knowingly false claims of election fraud to obstruct collecting, counting, and certifying the election results. Trump moved to dismiss the indictment based on presidential immunity, arguing that a president has absolute immunity from criminal prosecution for actions performed within the outer perimeter of his official responsibilities, and that the indictment's allegations fell within the core of his official duties. Make no bones about it. This indictment was profoundly and extraordinarily serious. It alleged that President Trump, among other things, criminally conspired to defraud the United States to overturn the legitimate results of the 2020 presidential election by making false claims of election fraud, organizing fraudulent slates of electors in 7 swing states, Arizona, Georgia, Michigan, Nevada, New Mexico, Pennsylvania, and Wisconsin, using the power and authority of the Justice Department to conduct sham election crime investigations and to send a letter to the targeted states that falsely claimed that the Justice Department had identified significant concerns that may have impacted the election outcome, attempting to enlist the vice president to use his ceremonial role at the January 6th certification proceeding to fraudulently alter the election results, and attempting to delay certification during the January 6th violent attack on the Capitol. The district court denied Trump's motion to dismiss, holding that former presidents do not possess federal criminal immunity for any acts. And that's Judge Tanya Chutkin all the way to the left. The D.C. Circuit affirmed, that would be the next 3 judges to the right. They affirmed, and both courts declined to decide whether the indicted conduct involved official acts. The Supreme Court granted certiorari. And these 2 men argued the case before the court, John Sawyer and Michael Dreeben. Now, let me give you the holding and the analysis of the case. The court divided presidential conduct into 3 types of acts. For official acts, where the president's authority comes from the Constitution and is conclusive and preclusive, the president has absolute immunity. For all other official acts, including those shared with Congress, the president has presumptive immunity, but the government can overcome the presumption by showing that applying a criminal prohibition to the act would pose no dangers of intrusion on the authority and functions of the executive branch. For unofficial acts, the president has no immunity. Now, for the law students in the audience, let me explain the court's rationale very briefly. So, argument 1, the court analyzes, says the Article 2 of the Constitution vests executive power in a president of the United States. The president's authority to act emanates from the Constitution or an act of Congress. The president's constitutional authority is sometimes conclusive and preclusive. That's the Youngstown case that Professor Bastress was talking about. When the president exercises constitutional authority that is conclusive and preclusive, Congress cannot act on and courts cannot examine the president's actions, nor may Congress criminalize the president's actions within his or her or their exclusive constitutional power. Nor may the courts adjudicate a criminal prosecution that examines such presidential actions. Therefore, the president is absolutely immune from criminal prosecution for conduct within his exclusive sphere of constitutional authority. Argument 2. Not all official acts fall within the president's conclusive and preclusive authority. The reasons that justify the president's absolute immunity from criminal prosecutions for acts within the scope of his exclusive authority do not extend to conduct in areas where his authority is shared by Congress. The court examined the framers' design of the presidency within a separations of power framework and presidential immunity precedent, which Professor Bastress explained earlier, to determine the president's immunity in this context. The court concluded that its separation of powers principles and precedents necessitate at least a presumptive immunity from criminal prosecution for a president's acts within the outer perimeter of his official responsibilities. So here, at a minimum, the president must be immune from prosecution for an official act unless the government can show, as I said before, no danger of intrusion on the authority and functions of the executive branch. Article 3 is simple: no immunity for a president's unofficial acts because the concerns for presidential immunity for official acts do not apply. The court gave very little guidance on what the key legal distinctions mean. Instead, the court explained that such a determination is a highly fact-bound inquiry best performed by the district court in the first instance, which is why it is remanded to the district court. And that the district court's job was to distinguish official from unofficial acts, distinguish official acts meriting absolute immunity from those official acts warranting presumptive immunity. I'd now like to turn this over to Professor Taylor to explain what that all means and its implications. Would you like to? Yeah. Absolutely.
All right. Thank you very much, Ann. Thank you all for coming out. Whenever I do a presentation where Professor Lofaso is involved and she has these sort of beautiful, elaborate PowerPoint slides, I'm like ashamed to have my own slides because they're so lame. So there were some things that I wanted people to be able to see to follow what I'm talking about. So I made some handouts and put them out, and so those are spread around. I apparently didn't make enough of them, but in any event, I will refer to that a little bit. The other thing I want to say is I've been told that I've got 10 minutes. Professor Lofaso normally just has kind of a vaudeville hook. In this occasion, she has brought an electric cattle prod. It is set on full. So I'm going to be monitoring the time very closely. Okay, so let me do that. Okay, I just cheated. I was going to start my little timer thing, and I didn't. So, okay, already behind. All right. I want to start out with the first line of Justice Thomas's concurrence from Trump v. U.S. Most of his opinion is about the special counsel, and Cody's going to talk about that later. But the first line, he says, few things would threaten our constitutional order more than criminally prosecuting a former president for his official acts. Okay? There are contexts where that sounds pretty good, pretty reasonable. Consider, for example, one of the statutes that's at issue in the January 6th indictment, 18 U.S.C. 371. The text of that is on the handout. It basically criminalizes any conspiracy for the purpose of impairing, obstructing, or defeating the lawful function of any department of government, right? Very broad, very open-ended. So imagine, if you will, that President Trump is elected in November, and next year he orders the Attorney General to initiate a prosecution of Biden under this statute for failing to enforce immigration law. That kind of direct order to the AG would violate all kinds of institutional norms, but as we've learned, norms are made to be broken. Or if you want to reverse the political valence, right, imagine that Biden had decided to order Attorney General Garland to prosecute Trump under the statute for failing to enforce environmental protection laws, something that he did not do. If we have to choose a world in which either both of those prosecutions are going to go forward or neither of them are going to go forward, and we can't like pick and choose, right? Which do you think is better for the country and our constitutional order? I would submit that if you think about this kind of case, most of us would probably say, thinking about those examples, Justice Thomas seems right? These kinds of prosecutions seem like a bad idea. And I think we react in that way because the language of official acts, we want intuitively to interpret in a certain way. We want to think an act is official because the president has the lawful authority to take that act. or at the very least, it's arguable that he has the lawful authority to take that act. And we believe that he's taken that act because of some good faith judgment, right or wrong, about what he or she believes in the best interest of the country. And we think we should not be using the criminal law as a tool to settle policy disagreements, right? And all that, I think, seems pretty right. It also helps that we naturally think that an official act can't really be unlawful, right? Because if the law doesn't support you, it wouldn't be official. We might call that what I call in the handout the naive theory of official action. Naive, not to say necessarily wrong or unintuitive, but to say that's kind of, I think, the natural starting point, right? But in contrast, things look rather different if we imagine that an official act basically means any conduct that either uses or abuses the authority of the presidency's the authority of the president's office for any purpose, good or ill. If that is what is meant, we might recast Justice Thomas's opening sentence this way. Few things would threaten our constitutional order more than criminally prosecuting a former president for his official acts, whether those acts are clearly lawful, arguably lawful, or clearly unlawful. I would submit that that sounds considerably less appealing. Justice Sotomayor puts it in a more dramatic way than that, but I've cut her quote for time, okay? Our topic is the immunity of former presidents from criminal prosecution. I had a roadmap that I was going to do that was going to be kind of 3 sets of 3 points. I think it's going to be more like 2 sets of 3 points. I'm not going to read them, but they're on the handout if you want an outline of where I'm going. Okay, so the first general area I want to talk about is to say a little bit more about how we should think about the immunity at issue in this case. And Bob talked a little bit about this, but I'm going to amplify and add to it a bit. The first thing I want to emphasize is that when we think about immunity in these cases, what's really important to the court is immunity is not a defense that can be offered at trial. It is something that keeps you from getting to the point of being tried, right? If you read Nixon, the Nixon case Bob talked about, or you read this case, the court talks a lot about the idea that the mere burden of having to go through the litigation for any period of time is really bad, is really burdensome, it's going to distort presidential judgment, even if the president ultimately prevails. So the idea is to cut things off early. Second point about this is that because immunity is about shielding the holder of immunity from having to go through the process of a trial, rulings about whether somebody is immune or not are subject to interlocutory appeal. And if you read the Trump opinion, you will see that the majority and Justice Barrett as well make a huge emphasis on this. And the practical implication, right, is that now on the remand, Judge Chutkan is going to have to sort out all this stuff about what's unofficial and what's official. If it is official, can the government rebut the presumption of immunity, all the things that Ann was explaining to us, right? And whatever she decides, before the case can go to trial, if Trump's lawyers are unhappy with this, they're going to appeal her rulings on those things to the D.C. Circuit, then back to the Supreme Court again before we even get to think about the prospect of actually having a trial, if indeed this case ever goes to trial. It certainly is not going to go to trial before the election, and so, you know, we will see. Okay, and then the last point, and maybe the most important one, is that the kind of immunity in question by design incorporates the idea that sometimes the president will be immune for doing things that are in fact an abuse of office, right? Both the Fitzgerald case and the new Trump case basically reject the idea that unlawful action is automatically unofficial. There can be official abuse of power, right? And you're immune for that too. There's a quote I put on the handout that I think is really clear. It comes from a case called Blassingame that was decided in the D.C. Circuit last year. Blassingame is basically a civil damages action against the former president arising out of injuries suffered in the course of the events on January 6th. And Judge Srinivasan is glossing Nixon versus Fitzgerald, and he says, the president's actions do not fall beyond the outer the outer perimeter of official responsibility merely because they are unlawful or taken for forbidden purpose. Rather, the president's official immunity insulates all of his official actions from civil damages liability, regardless of their legality or his motives. Now, I would submit to you that the idea that the president cannot be criminally tried for all or nearly all of his official acts, no matter how unlawful they may be, seems intuitively unappealing and prima facie doubtful. 2 points about that. Judges and prosecutors have long been held to be absolutely immune from civil damages liability for their functional decisions, for judicial rulings, for prosecutorial decisions, and so forth. Yet the court in those cases has said, civilly immune, but can you try them criminally? Yeah. Right? The other point, and Bob made this well, and Sotomayor emphasizes this a lot in her dissent, I think the conventional wisdom which I share is that presidents have always assumed that they could be criminally tried if they ran afoul of the criminal law. Generally speaking, presidents give it a wide berth, right? They don't want to be in the dock, right? But as Bob pointed out, you can't understand what the Ford and Nixon situation except as presupposing the idea that they believe that there could be charges brought, right? So why does the court recognize immunity for even clearly unlawful acts, and could this be defensible? Now, I think the answers there are different for the two kinds of immunity. I call them the two buckets, and did a nice job of explaining the first bucket. That was something I wanted to talk about, and I concluded that it was going to take too much time to explain it, and did a pretty good job of explaining it already. Suffice to say that the basic idea that the president can't be prosecuted for actions within his exclusive, conclusive, and preclusive power does seem to me right. What seems to me wrong is the court just casually says everything involving interactions between the president and the DOJ falls in that sphere of exclusive Article II authority, something that I can imagine the court hinting at, but something they've certainly never held. They've held it now in a very casual way. How far is that going to go? That's a big topic. I find it very concerning. But I'm going to move directly to Roman numeral 5, my last point, which addresses the sort of second bucket of immunity, the idea that official acts are presumptively immune unless the government can demonstrate that prosecutions in this area would not pose any threat at all to executive function. Now, in this case, in this kind of immunity, again, the claim is not really, holy crap, cattle prod coming out. Okay, so real quickly, right? First of all, really unclear how this is going to work, right? Take the actions with Pence, right? The court has already said that's official conduct when President Trump allegedly is trying to convince Vice President Pence that he should decide not to count certain electoral votes, right? Is that presumptively immune? It matters a lot how you frame the question. Do you frame it specifically, right? Would it interfere with executive branch function when the president is forbidden or prosecuted for trying to persuade the vice president to disregard his constitutional duties and steal an election? My guess is if that's the way you frame the question, it seems pretty clear that you can be forbidden from doing that without interfering with the legitimate functions of the executive branch. But I suspect the court may wind up thinking the right framing is something like, if you allow criminal prosecution to involve conversations between the vice president and the president, will that interfere with the functioning of the executive branch? And it's pretty hard to disregard the idea that it might, right? So how you frame the question, what the standard is, I think is going to drive the outcome, and nobody really knows what that is. So Chutkan is in a tough spot. Last point I want to make, and I'll make it very quickly, and Bob hinted at it, at the end of the day, when we make people immune from prosecution, there is a cost. Bad things are happening. One of those bad things is the conduct that deserves punishment is not being punished. What's the advantage on the other side? And the court's big advantage are two things. They claim that the threat of possible future prosecution will make presidents unduly timid and hesitant in carrying out their duties. And that's bad because the founders wanted a unitary executive who was energetic and decisive and all those things. and the idea that, as Chief Justice Roberts puts it, the executive branch will cannibalize itself. Which of those fears you think is more realistic, where the balance lies, depends on the answer to a lot of empirical questions, which I would love to enumerate, but the cattle prod is coming out. So I'll just say, I will just say, basically, it's sort of armchair cost-benefit analysis. Not clear to me Supreme Court justices are any better at that than anybody else, but that's kind of what a lot of the opinion rests on, and basically the court's bet is the risk of kind of tit-for-tat prosecutions of former presidents till the end of time is so great that we've got to nip it in the bud now. I will stop there. Thanks for listening.
We'll now hear from, well, first of all, John's getting the cow prod because he said, I did a pretty good job, okay? So he's in trouble. No, I'm kidding.
Because you didn't have enough time. With
Of
more time, it
course.
would have been an extraordinary
Of
job.
course.
It was an
Thank
excellent job for
thank
the
you.
scope of the assignment.
Thank you, Professor Taylor.
You're welcome.
But we'll now hear from.
I think that means he gives her a B+.
Oh, my.
Don't go there. Don't go there.
Don't go, my. Okay, we'll now hear from Larry Rosenberg.
So Richard Nixon, I think, put one theory of executive immunity like this. If the president does it, it's not illegal, right? That's the broad theory of presidential immunity. And I do want to commend everyone who went before me. I think they did a wonderful job. I'm going to follow up most directly on Professor Taylor's remarks. I would, by the way, give all of them an A+. But then I'm an easy grader and I run into trouble. So, but I would say that the broad theory of executive immunity is definitely what President Trump is pushing in the current criminal cases. And I think the slide up shows a brief outline. We have the January 6th cases, which I'm going to spend the most time on because they're the most serious cases. We have the classified documents case. We have the hush money cases. I think the easiest to talk about in some ways is the hush money cases, right? Because the theory in that case, and President Trump has been convicted in that case, is that he manipulated documents, falsified documents, made false statements effectively in his business records to cover up money that was paid to Stormy Daniels so that she and others would not come forward about their supposed affair during the 2016 presidential campaign. And you can debate whether that's really a crime, and I think there are real questions about, under New York law, whether that is enough of something that's actually illegal and that's something that would be charged against anybody but somebody running for president, perhaps. But putting that aside, it is hard to imagine how that is an official act, right, under any of these theories. Does the president as an official, he wasn't the president at the time, right? So this was stuff that was done when running for president. And is it an official act of a future president to previously pay money to somebody not to talk about their alleged affair? Probably not. So although, be that as it may, President Trump has already filed multiple motions in that case, saying that that case needs to be dismissed because of the official immunity case. And, you know, all I can say is it's hard to understand how that is so. So, you know, in some respects, I think the hush money case is the least significant because it's a really questionable case on the actual law, but it's also the case farthest from the official acts that the Supreme Court has said immunize the president. The second case, and I believe we're going to hear more about this on the special counsel discussion, is the classified documents case. And that case has been dismissed on the ground that the special counsel acted outside legal authority. But put that to the side. Are classified documents something that are part of the official acts of the president? Well, of course they are. But are they something that are part of the official acts of the president when, after the president is out of office, he steals the documents and then lies to multiple government agencies about it, right? That's a little bit of a different question. One thing I do think that may be a useful filter to think about some of these cases is that if the person being prosecuted were anyone other than Donald Trump, not just the president, anyone other than Donald Trump, would they be in jail for those actions? And at least in the classified documents case, as someone who used to be employed by the Justice Department, as someone who knows many, many people who have been employed by various branches of government and the military, and who's familiar with other classified document cases, if any other person took documents that were classified after their service in the government and then and took many of those, didn't properly secure them in a secure document facility, and then lied to government officials about whether they possessed those documents, you better believe that person would be in jail. I mean, there's the example that is sort of a common of the woman who worked, can't remember for which agency, but was working for a defense contractor, had access to classified documents, took one page of a classified document back to her hotel room so that she could take notes on it for an academic paper she was writing, returned it the next day, there was no breach of anything, and she went to jail for 6 months. So if that happens, you can only imagine somebody intentionally stealing documents. But the real question that's going to come up with the official acts is, when does the official immunity, cloak that the president enjoys end? Is it the day that the president is out of office, or does it somehow shield the president in perpetuity from any acts that were at least arguably within the ambit of presidential power? And so that's the argument that's going to eventually be made in the classified documents case, if it's ever resurrected on a different basis, is because certainly getting those classified documents in the first place was an official act. Does that therefore forever immunize the president for prosecution from any misuse of those documents? So let's turn then to the January 6th cases. And I think Professor Lofaso did an excellent job summarizing that. If you could go to the next, oh, she's already gone to the next slide. This is just an interesting quotation that I found and used in a different presentation from one of the district court decisions about the January 6th rioters, sort of summarizing what went on. But just to summarize for a minute what President Trump's involvement was, right? You all probably know this, but during, President Trump gave a speech where, in the context of this Stop the Steal rally that had been advertised for several days, gave a speech that urged the people to effectively prevent the certification of the vote. I mean, he disputes exactly what he meant, but urging them to go down to the Capitol and to stop the steal. They then went down to the Capitol. Many broke into the Capitol. Some of them used violence. Several police officers lost their lives as a result of it. All the while, President Trump was back in the White House for approximately 2 hours, said or did nothing to the crowd, while apparently members of Congress, members of his own administration, members of his family were all imploring him to tell those protesters, those rioters, to stop. And then he eventually tweeted out some rather tepid remarks that he interpreted as saying, "Don't be violent." All the while, these protesters were chasing down Congresspeople, were looking to Vice President Pence to potentially hang him. People were trying to find the vice president to murder him. And again, the president did very little at all to try to stem that. He has a different take on it, of course, but that's sort of what happened. So when you look at that, you can sort of wonder what are the possible charges that would be brought. If you go to the next slide. The main charge that involves President Trump, which is the charge that was at issue in the Fisher versus United States case, is obstructing the certification of votes for president. And that statute, it's based on a statute that was enacted in the light of the Enron scandal, which was a document destruction case, to be sure. This statute says that whoever corruptly, and number one is alters, destroys, etc., with the intent to impair the object's integrity or of availability for use in an official proceeding. That's a document. Or 2, otherwise obstructs, influences, or impedes any official proceeding or attempts to do so. And the argument that the Supreme Court accepted in the Fisher case is that that term otherwise obstructs actually means likewise destroys documents. And that is a position that my former partner and mentor, Judge Katsas on the DC Circuit, articulated in one of the January 6th cases, that otherwise has to be read in context, in paramateria, using various canons of construction to refer back to the topic of subsection 1. And so it can't mean what normally otherwise would mean, which is in some other way. It has to mean likewise. This was a very cramped reading of the statute, but this is the reading that the Supreme Court adopted in the Fisher case. How does this relate to President Trump? Well, in order to convict him under this statute, the special counsel is going to have to prove that the actions that he undertook were to alter documents. Now, he has a hook there because the certification of the votes itself involved documents. It wasn't just a voice vote, it was actually certifying documents. And so there is an argument that even under this narrow reading in Fisher, you can still prosecute President Trump as inciting this mob to prevent the proper certification of these documents, potentially destroy the documents. And that is part of what is alleged in the indictment. And so let's talk a little bit. I mean, Professor Lofaso summarized this, and I'm getting close to time, right?
Yeah, I'm going to give you a couple of extra
Okay.
minutes.
All right, so I'll finish this in 2 minutes. Basically, there are 3 theories in the indictment, and there was a 4th theory in the January 6th case, which involved the Attorney General and disregarding the Attorney General's statements about fraud and conspiring with the Justice Department. That's been taken out because the Supreme Court, as our predecessors made clear, have said that the communications between the President and the Department of Justice are absolutely immune. But the 3 other pieces of this that remain in the indictment are, number 1, lying to the American people in a way to deprive them of their legitimacy of their votes, to say that there was widespread fraud when there wasn't, and that the president knew there wasn't. Number 2, interfering with state electors, the slates that Professor Lofaso mentioned in those 7 states, to try to get them to have this false slate of electors. And number 3, the charges with respect to the rioting at the Capitol, this attempt to obstruct the official proceeding. And so what ultimately is going to have to get sorted out is what of that are official acts, right? And President Trump's going to say they are all official acts, right? I was the president. I was conversing with the vice president about an important legal matter. That's an official act. I was conversing with or communicating with state electors about doing their lawful duty. That's an official act, even if the lawful duty that he said they were talking about is to ignore lawfully cast ballots. And certainly with the attack on the Capitol, he's going to say, I had every right, he said this during the debate last week, I had every right to give a speech to my supporters about my view of the election. That's an official act. So he's got that argument, and the counter argument is going to be some variant of, yeah, but that's not really within your official acts as president. Maybe that's something where you were running as a candidate. Maybe you had a concern about the way the election was run, but you were acting in an ultra-virus, but beyond your authority capacity. And that's sort of where the fuzziness of the opinion becomes difficult. Because if it's anything within the outer ambit of something that can be argued to be related to your acts as president, it's probably all covered. But if there's some dividing line that the court didn't articulate in the opinion, that if it's really, really not part of the central thrust of what you're doing as president, it's not legal. And I'll just close with this sort of example that came from the argument, I believe, in the DC Circuit. The question was posed to President Trump's lawyer. If President Trump ordered federal officials, federal assassins, to assassinate his political opponent, would that be immune from prosecution? And the lawyer said it would. It would. Now, certainly, if the president ordered a terrorist to be killed by a drone, you would think, even if that was wrong, even if it wasn't a terrorist, et cetera, but had a plausible basis to believe that the president was ordering, the assassination of a terrorist, that probably would be within the official acts. But somebody who's a political opponent with no other basis, you would think that wouldn't be an official act, and yet this broad reading of presidential immunity would probably make it so. So there's the conundrum that this decision poses and the difficult issues that the courts are going to have to address on remand.
Thank you, Larry, very much. We will now hear from Professor Corliss about the special counsel implications.
Thank you. Excuse me, and it's a real pleasure to be part of this panel. I'm here joined by 3 constitutional law experts and a Supreme Court litigator, and many of you may be wondering, what's my 1L crim law professor doing up here? Well, part of my research and part of my scholarship deals specifically with the special counsel and the role of the special counsel upholding the rule of law. And when we talk about this term, rule of law, it's kind of a broad term, and there's no precise definition about what the rule of law means. But generally, there's this idea that the rule of law requires publicly promulgated laws, and that those laws are equally applicable to all individuals. So when I speak about the rule of law, keep that in mind. Now, first of all, I want to touch on something that Larry Rosenberg talked about and how this case has gone now to remand after the Supreme Court decision this summer. That it'll be remanded to the district court, where that court will have to parse and determine what falls into the bucket of unofficial acts. And what's interesting is since the Supreme Court decision in Trump v. United States, the special counsel has already acted. And the special counsel has filed a superseding indictment. And that superseding indictment really reframes the debate. Previously, the superseding indictment said former President Donald Trump. Now that superseding indictment says Donald Trump, candidate for president. So so we can see, even as the special counsel makes, there's legal strategy involved, and we see the special counsel doing his best to reframe the debate, to push things into that unofficial acts bucket. Now, so keep that in mind and pay attention to that going forward as we see how this case plays out. Now, I want to talk about more generally about the special counsel generally. And I mentioned my research and my scholarship focuses on how the special counsel upholds the rule of law. And there's a long history in the United States of using independent prosecutors to investigate executive branch officials when there's a conflict of interest that means the Department of Justice can't investigate itself as an executive branch official. And these go back since the 1870s. President Grant first used them. They were used in the Teapot Dome scandal. They were used during Watergate. And the current special counsel provisions date to the end of the Clinton administration, 1999, when Attorney General Janet Reno created the statute under the Code of Federal Regulations, the CFR. Now, interestingly, there are 2 kind of cases here, right? As all of my fellow panelists have talked about. We have the events of January 6th. That's the Trump immunity decision, Trump v. United States. There's also the classified documents case. Now, interestingly, the January 6th case goes before the Supreme Court, and we have a concurrence in that January 6th case where Justice Thomas says he wants to address essential questions about the constitutionality of the special counsel. Now, interestingly, no one else seemed to be too concerned about these essential questions. This special counsel statute had long been the subject of litigation and had always been found to be constitutional. And Justice Thomas's concurrence speaks in really ambivalent terms about these essential questions as he frames it. And he says, I am not sure that any office of the special counsel has been created. He's not sure. And he says this prosecution may violate our constitutional structure. Again, a bit ambivalent. But interestingly, Justice Cannon in the District Court for the District Court of Southern Florida uses Justice Thomas's concurrence as a roadmap for dismissing the classified documents case. And Judge Cannon says that there is no authority to appoint the special counsel, specifically that Congress didn't authorize this because it was through the Code of Federal Regulations. But interestingly, another case we talked about in today's panel, U.S. v. Nixon, relied on these exact same statutes to justify the use of a special prosecutor. So how does Justice Cannon deal with past Supreme Court decisions that specifically cite these statutes as the basis for special prosecutors? Justice Cannon does something really strange and quite unprecedented, I would say. And I'm not a constitutional law expert, so I'll leave it to the constitutional law experts to tell me just how strange this is. But Justice Cannon says dicta, and she just completely sidesteps it and says it's totally dicta, even though the U.S. v. Nixon, the court acknowledged these statutes as the basis for creating a special counsel. And so Justice Cannon dismisses this case, and it's currently on appeal with the 11th Circuit. And it's a decision I think that has largely been criticized by it has been largely criticized by constitutional law experts who know a lot more about constitutional law than me. But that's something to watch going forward to see what happens. Finally, when I first read this decision, this Supreme Court decision, I thought it was quite compelling initially. I thought there's some interesting reasoning. That's true, as Professor Taylor says. We don't want to subject our presidents to criminal prosecution. But the more I read it again, and it made me very concerned. And I think there's a lot of questionable judgment, legal judgment, and legal reasoning in this opinion. And particularly when it comes to official acts, the Supreme Court says not only are official acts immune, but you can't even use past official acts as evidence. That's a really big step. And if you look at the decision, the Supreme Court offers this very odd, poorly worded footnote number 3, which seems to suggest that you can't prosecute a president for bribery, since bribery by its very definition is promising to do an official act in exchange for money. And so there's a lot of questions. If you can't show that an official act was done, how can you even prosecute the bribery if a president commits bribery or engages in bribery? So those are some big questions about the decision. I don't have a lot of time, so I'm sorry. One thing that I want to note, though, is the Supreme Court justices argued that they were writing for the ages here, and that was something that Justice Alito said in oral argument. Justice Kavanaugh said the same thing. We're writing for the ages. But I don't think you can separate the facts of this case, and that these are based on acts of one specific individual, former President Trump. And what concerns me from a rule of law standpoint is that the former president has made every indication that he will not abide by the rule of law, and has specifically said that acts committed by the president can't be prosecuted even if I cross the line into criminality. And that's a really big statement coming from someone running for the office of presidency of the United States. And even what's more amazing, after this Supreme Court decision, I think President Trump is right. Yeah, he may very well be right. And The dissents in this case by Justice Tanji Brown Jackson and Justice Sotomayor really speak to that issue, and then how do we then separate what do we do about a president who seems hellbound on engaging in illegal acts within the context of their presidency. And with that, those raise real questions about the fundamental rules of law and the fundamental rule of law in the United States. So, thank you. Happy to answer any questions.
We do have some time for Q&A. And so, because classes don't start for another half an hour, but we're going to have Q&A for about 10 minutes. Does anyone want to ask the first question?
Yeah, I just had a quick question about pardons, particularly Nixon's pardon. Was that for everything he had done up until that point, or was that for something Watergate specific? And in accepting a pardon, does that imply guilt on the president's part?
My recollection is that the pardon was framed in terms of any acts that he committed while acting as president, or words to that effect. So it was not limited simply to the Watergate scandal and the cover-up.
And it would be federal.
Sort of like mainly that, but in
Would
the
be
case
federal.
there's anything else, I'm pardoning him for that as well.
Yeah, I think that's the way I read it.
Vietnam-related actions, whatever.
And I don't know that his acceptance of the pardon, he did formally accept it, was necessarily an admission of guilt. It was certainly.
I read something over the weekend that seemed to suggest that is conventionally understood as kind of an admission of guilt, but I'm not 100% certain, and I don't remember exactly what it was.
Well, I don't know. It
I
seems to
don't
me
know.
an individual could easily accept a pardon, even though they didn't do. I do that all the
Yeah,
time.
yeah. I mean that seems like the more likely answer. I
Maybe
agree.
just the admission that he might be criminally prosecuted, right? I mean, I don't think it's an admission of guilt, but I think
I
it's an
think that's
admission
true.
that he was worried that he would be criminally prosecuted,
Yeah.
which means he thought he could be criminally prosecuted.
Right. I
That's
would draw
certainly
that
true.
inference.
Yeah.
Yeah, but I've also read that it goes beyond that, but technically, you guys are right, that it just is an admission that you could be criminally prosecuted. By the way, the president can only pardon you for federal crimes, not for state. Just want to make that clear to the law students. Are there other questions? Okay, I saw.
Staying on the topic of pardons, do you believe the president has the power to pardon himself?
That's been raised, and I think the answer is we don't have it.
Yeah, it's never been settled. My sense is that conventional wisdom. There's some OLC opinions that speak to this a little bit, aren't there?
I don't know.
I think there might be. But I think the conventional wisdom is that, the idea that you can't be like the judge in your own case, that's kind of a basic maxim of justice going back, hundreds of, multiple centuries, right? And the conventional wisdom, I think, is that the president can't do that. And then, you've got this idea. I mean, after this case, the court has sort of reaffirmed the notion that the pardon power generally is one of these exclusive, conclusive, and preclusive exercises of power in Youngstown terms, which you'll recall, right? This is in the area where even if you're in box 3, the president can still win. And that kind of complicates a little bit, but I imagine the notion would be self-pardoning is just not included within the scope of the power, and maybe the court could rule that and therefore basically use its power to invalidate a self-pardon.
But
I
the
think. Go ahead. Larry.
Well, I was going to say, but the president could theoretically resign one day before his office ends, and then the former vice president, now president, could pardon him on the way out. And there were a lot of suggestions that that was a mechanism Trump might use in the prior term, and even more so in this current term, if he were reelected.
If he trusts that, but he could also just say, he constantly gets away with norms, throws out norms, and this is really a norm as opposed to a actual law. So I think Trump would argue that he does have that power, and
Right, and
who
so,
knows?
right, I mean, play that out. He pardons himself, right? And then somebody later tries to prosecute him for the crimes for which he pardoned himself. And then he says, well, because I pardoned myself, these crimes are now protected as official acts. So you can try to, backdoor it that way potentially.
Yeah, I think the Trump court, the court in the Trump case, one might also call it the Trump court, I suppose, but made it pretty clear that that majority considered the pardon power to be one of those unreviewable areas of executive power.
So I wanted to ask, this is very much a theme of consolidating power within the presidency, protecting that power from already civil liability, but now criminal liability as well. This might be a step too far, but can we contrast that with the theme of decentralization of executive power with the overturning of Chevron? Do you see them as two completely dividing logical themes with a seemingly conservative court, while we're trying to take away that executive power of interpretation, while also at the same time consolidating executive power in one person for that acts, for their interpretations and acts?
Well, I think the premise of the question has to be explored, because I don't think the Chevron decisions take away from executive power. They take away from administrative agencies, and that power actually gets consolidated there in the courts, which of course the judges are selected by the president. And so, arguably, if anything, the Chevron cases are favor the presidential power. So I do think they're consistent in that regard. Again, you have a president in Trump who's extremely hostile to administrative agencies. Was in his first term, would be even more hostile. Said he's going to dissolve many or all of them if he gets elected. I mean, he's so I do think it is consistent in that way.
It could, but I think there's also some other additional nuance, because it really is strengthening the court's power more than anything. And so, and the president has power over its agencies, but not independent agencies. And so, like the NLRB, right now, yes. So, in a sense, it weakens it for the independent agencies, but strengthens it for the other agencies, because then the president could just fire them. Although the president has, if President Trump wins, he does say that he will implement something very similar to the 2025 proposal, which is that he would go up the ladder and fire most civil servants. So let's try to take two more questions, and we'll go here and then.
Given that, so for the January 6 cases, since it's on remand, let's say the judge finds that it was an unofficial act or that the government has met their burden for the presumption. Do you think that this would ever come to like a practical resolution? Like, would it keep going up to the Supreme Court and they reverse and remand and then the judge tries again? Do you think the prosecutor would just give up at some point? Like, will we ever see a real resolution for this?
There's some tactical maneuvering going on in the district court now about how this is going to go. And basically, the Trump lawyers are trying to sort of divide it out and basically say, can't we get Judge Chutkan to sort of rule on the bucket of factual allegations involving Vice President Pence and say whether those are immune or not, right? And then their hope is they can get her to rule on that, and if she rules for them, they think the whole case goes away. I don't think that's really true, but that's kind of the gambit. But then you would kind of get two rounds. And in contrast, the special counsel was very much trying to say, yes, I get the idea that whatever she does, ultimately it's going to get back to the Supreme Court and they'll really make the final calls about how to apply this scheme that they've created, right? But they're trying to make sure it's all done together so we can do it in one pass, right? But at this point, I think everybody agrees that there is zero chance that any of this is going to get resolved before the election, and that's been true for a long time. And then if Trump becomes president again, he certainly kills the federal prosecutions, right? And whether they could be revived or not is I'm sure a complicated question, but it puts it a long, long way into the future.
And if Trump loses, the question is 2 or 3 years down the road, is anybody going to really want to prosecute
Yeah,
an
that's true.
81-year-old of questionable sanity at that point?
I heard somebody say that their theory was that the Supreme Court thought that they might not have to see this again. Maybe on that theory, but I suspect they will see it again, and they'll have to kind of decide what to make of the very vague guidance that they've laid down in the opinion.
I think the last comment there kind of goes to this question where you said if someone was 81 years old or out of their mind, would someone still want to prosecute this? I think the backdrop to all of this is the fact that people see the Department of Justice being politicized against political opponents. And that's what the Supreme Court's reasoning was, is that we don't want the justice part of the Constitution to become a politicized document. And what you just mentioned, oh, well, he's no longer running for president and he's 81, so we don't care about prosecuting anymore. That would lend to the credence that this is being done because you want to keep him out of office or returning from office. So with the politicization being the backdrop, and some people saying, for example, well, you didn't prosecute Obama for killing a United States citizen summarily overseas without due process. No one cared about that because it was understood that future presidents don't prosecute their political opponents criminally, which is why this is unprecedented in the first time. And I think Professor Taylor mentioned in his class that you've seen that position, that it's probably not a wise idea to just uniformly prosecute your political opponents because of the carnage that leads to it. So 2 questions. One, does that backdrop of the politicization of the Department of Justice lend any credence to the opinion that was given in Trump's? Because I didn't really hear a discussion of the politicization of it much from y'all's opinion. And then number 2, if the president doesn't have the power to declassify documents, who does? Like who? If the president, the elected person, doesn't have the power to declassify his own documents, who else would have more power and authority than the president to do that?
Can I say something about the first set of things? So on the Obama thing, this is actually discussed in the briefs. So one of the things that happens is that there's this question of to what extent are these situations analogous to kind of civil damages actions, and to what extent is the criminal scenario different? And Bob talked about some of the reasons why it's thought to be different. The special counsel, Mr. Dreeben, I don't know if it's Drebin or Dreeben.
Dreeben.
Thank you. Mr. Dreeben in the brief really sort of took the tack of trying to kind of beat the court head on and say, look, I recognize that you guys are worried about things getting out of control. Let me explain to you all the kind of built-in checks on presidential prosecution. And the drone strike thing was discussed, and basically OLC has a practice of sort of looking at various statutes and arguing that there's sort of an implicit public authority exception as a matter of statutory interpretation of those statutes. That's how they handled the Obama thing. So to the extent that some people were saying, there's been criminal action that hasn't been prosecuted, Dreeben was saying, actually, that's not true, and then pointing to OLC's practice in this regard as kind of evidence of the various safeguards that make these hurdles hard to mount, right? But to speak to your broader question, what I was going to say if I had more time, and so I'll say it real quickly now, is when you think about the cost-benefit thing, and then you think about how much is this about Trump, and is Trump kind of like a case of one, or is this a case about presidents in general, you really find the 2 sides of it going in very different ways, right? And I think one might debate the wisdom of bringing certain kinds of charges against presidents, even if you think they could be proven, right? It's not always the best idea. I think for the dissenters, the idea is that what we've got here is so outrageous that you can't not prosecute it, right? And what happens is the dissenters in their questions are really trying to say, look, this is kind of a one-off. This is a uniquely serious situation, and we've got to pay attention to what this guy did and the dangers of what somebody like this would do. And the conservatives are like, we're not talking about this case. We're making a rule in general. We're up on Olympus, sort of looking out. We're making a rule for the ages, all that kind of stuff. When it turns the other way, and the question is, are we going to have lots of prosecutions of presidents? The dissents and Mr. Dreeben's brief are kind of saying, here are all the checks that are going to keep that from happening. It's never happened before. That's why. This is kind of a one-off. And the majority is basically saying, we're not so worried. Nobody's going to order SEAL Team 6 to assassinate a political opponent. But what is going to happen is that we're going to start tit-for-tat prosecutions, starting with, guess who? President Trump, who will argue politicization, weaponization, all that language. We're going to prosecute Biden for whatever, right? And the majority, basically, their bet is that danger is a much more present danger than the other danger, and they think, I believe, that they are engaging in an act of judicial statesmanship and sparing the country from that by putting things off. That, I think, is, if you got them, over a beer and off the record, my guess is that that's what they would say they are doing.
Yeah.
Okay,
And
I'm
whether
going to take
that's right or not is obviously debatable.
I'm going to take moderator's prerogative to just finish up the answer, and then so we can get one more question in, which is that on your second point was who the president, if the president can't declassify, who can? The president can declassify. He just didn't in this case.
Correct.
So that was, if he had declassified, there'd be no case. Now, he can argue he did, and then that would be a question of fact. So that's
Yeah, but
what's going on there.
There's a process to do that. The
That's
president
right.
just doesn't wave his wand and it's
Yeah.
declassified. There's paperwork that has to be filled out. It has to be reviewed. There's an official process to do it. He didn't do that process.
We're going to go on to the next question, okay? Because we did a lot on your question, and I promised this person that he would get.
Yeah, I was just going to ask about, to expand upon the rules of having a special counsel prosecution and how that's constitutional. Because, on one hand, I kind of see the Republican gripe about this. You have, Biden's attorney general appointing a special counsel prosecutor to essentially follow around his main political rival and can indict him in any jurisdiction. And then, on the second hand of that, I seen Jack Smith's picture in the slide, and you can literally find this man's X account. And I mean, he is rabidly partisan. And it was always my assumption that prosecutors had to be fair and balanced. Like, for example, yesterday he suggested that President Trump faked his assassination attempt. So he's clearly not a big fan. I'm just curious to how that can work.
I just want to say one thing on the Twitter account, his X account. That's actually not his account, the one that's saying that. There's a fake account out there that says that's not. Yeah, so that one is not. He would. That's not. There is a. That's been shown. But let me have them answer your question, okay?
So the question, I think, is about constitutionality of a special counsel. And I think your broad question is about why do we appoint or what's the purpose. And I think you should think, more broadly speaking, is we use special counsel. The Code of Federal Regulations require that a special counsel who is appointed is external to the government, so is someone who is not currently part of the Justice Administration. That's a key requirement for appointing a special counsel, with the idea that this individual will act independently. And so let's think why we do it more broadly speaking. It's to preclude conflicts of interest that are going to be inherent when the Justice Department, the Attorney General, and executive executive branch official has to conduct some investigation. Now, sometimes it can be a conflict of interest if you're investigating a fellow executive branch official. Think about the Mueller investigation. That was actually started by a Republican administration. That was a Republican attorney general. So and similarly, the investigation of President Biden's classified documents was also initiated by Merrick Garland, a Democrat. So it's really, I would think of it, it's constitutional. Well, I guess it's, according to Justice Thomas, there's essential questions about its constitutionality, but it's generally been considered constitutional because it's a statute authorized by Congress.
Yeah, one thing I think that we need to clear up about the special counsel, President Biden did not appoint the special counsel. The Attorney General appointed the special counsel. And while it is possible, certainly, that there were some communications between the President and the Attorney General about that, it is the Attorney General who appointed him, and it's the Attorney General who has said it was absolutely his responsibility and his decision to do that. And so, you know, you can criticize that decision. There are certainly plausible arguments that maybe that wasn't a good idea, but it's not the President who does it, and that's something, you know, that for example, in the debate, former President Trump continually refers to this as Biden's prosecutor. He's not. He's the Attorney General's prosecutor.
And again, the idea as a special counsel is the intent is to serve as an independent prosecutorial authority, somewhat divorced from the Department of Justice.
So I just want to thank my my co-panelists. I know that not all of you got to ask questions, and Kyler, you had some more questions. So we invite you to come and speak to the panelists for a few minutes. But let's thank the panelists for their presentation. And I also want to thank the audience for having disparate views and for bringing up their views and for engaging with the panelists. Thank you so much.
I have no knowledge of Jack's Twitter account, but I find it impossible